Okay, thank you very much for waiting, everybody. Good morning. Welcome to today's licensing subcommittee. The first item on the agenda is appointment of the chairman. Is there a proposer for chairman, please?
Yes, I'll propose. I propose Nigel Berry.
Thank you, Councillor Phillips. Is there a seconder?
I'll second that, thank you.
Thank you, Councillor Humphreys. Councillor Beryl, you've been duly elected chair of this subcommittee. Over to you.
Thank you very much and good morning. Welcome to this alcohol licensing committee. As you all can appreciate, I'd like to start off. These are very difficult via Teams and via Zoom. So please, I thank you in advance for your patience and we shall move on from there. So let's start off with the introductions for the subcommittee initially. I'm Councillor Beryl, the chair that's been appointed for this committee. Caroline Phillips, please introduce yourself.
I'm Councillor Caroline Phillips on this committee.
And Councillor Humphreys?
Yes, Councillor Rosie Humphreys, thank you.
Thank you very much. And the clerk and legal advisors, please.
Ed Bostock, Democratic Services Officer.
James Chadwick, legal advisor to the subcommittee.
And the licensing authority staff?
Yes, Michael Sands, West Northants Licensing.
Thank you very much. Okay, so before we go on to the introductions of the applicant and the objectors, I do have a list of people here, because as you can appreciate, again, it's very easy to people to speak over one another here. So I do have a list. So we're going to go through the list first, and you will please introduce yourselves and what you're representing for, either the objector or representative, and we'll go from there. So if we could start off with Sarah Glover, please.
Good morning, Chair. It's Clover, Sarah Clover.
Oh, big pardon, it's a G here. No worries.
Oh, no worries. I'm the barrister on behalf of Casper Restaurants making the application, so I'll be presenting on their behalf. Thank you.
Thank you. And Perry Akhtar.
Yeah, hi, good morning. I'm the franchisee at McDonald's in the Northampton area.
And Mark Buckley. Mark Buckley, please introduce yourself.
I don't think Mark Buckley is here, Chair.
Yeah, he's here. I can see him on my screen, Ed. And Mark Buckley, you seem to be on mute. Okay, well, he's having a few technical issues. Let's move on. So we'll come back to Mark. So we can have Daryl Butterworth, please.
Apologies, I'm the operations manager for McDonald's in Northampton.
Okay, so that was Mark. So do we have Daryl Butterworth? Is he in the room? Just checking the screen. Yes, Daryl, please, if you can introduce yourself, please. You have technical issues. James, where do we stand with that? Can Daryl still attend if he's on mute, if he's having technical issues?
Well, yes, he can. If it's intended for him to address the subcommittee, he'll have to sort his technical issues out.
Okay, thank you. John Crick, please. Just looking for John Crick.
Sorry, I'll speak on behalf of John Crick. You didn't invite John Crick in time for him to make plans to attend. For some reason, he was omitted, even though he does the Residents Association for the Avenue, and he was omitted from this hearing. So just draw attention to that he only found out about this on Sunday via myself. And I didn't find out until my wife told me. So I wasn't invited either. So there've been a number of, let's say, procedural issues with this hearing, and protocol hasn't really been followed. I'd like to draw that attention to the committee.
Okay, thank you. And is this Andrew Beck that's just spoken? Is that correct?
Yes, it is. Yes.
Thank you. And obviously you're registered to speak also, so that's absolutely fine. Okay, so that's as far as my list goes. So please introduce yourself one at a time if your name hasn't been read out.
Can I come back in there, Chair, with your permission?
Yes, please, Daryl. Yes, please.
I've sorted my technical difficulties out, thank you.
Good. Please introduce yourself, Darryl.
Yeah, my name's Darryl Butterworth. I'm an independent licensing consultant.
Thank you very much. Do we have any more in the room? So Ed, Rosie, CC, CC, please.
Yeah, CC Beck. I'm here. Yeah, I'm here. I'm representing a resident who's obviously affected by this development.
Thank you very much. I'm just literally checking the rest now. It's quite difficult via Teams and Zoom. I'm sure you all can appreciate. And Mark Buckley. James, can you confirm everyone's introduced themselves? I think I'm pretty good my end. Ed, can you help me out, please? Is everyone introduced themselves?
Yeah, that looks about right. Yeah.
Okay.
Yeah.
Thank you very much. So let's please continue. So what I'm going to do here, I'm going to take silence as a yes, because as you can appreciate, everyone's going to be saying yes, 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 yes. So I'm going to take all silences as a yes. And if you need to say something, then please raise your hand or by pressing the icon on the screen. So have all parties received a copy of the agenda for today's hearing? Again, just confirming, I will accept that as a yes.
Well, could I just make a point on that particular subject, because I submitted a legally bound written representation that was omitted from the pack, and it made a number of objections and also cross-referred them to legal points. So I have respectfully asked Michael Sands if I could have additional time to read out my representation, which has been validly served on the council, which for some reason has been omitted. I did draw attention to various procedural problems with this hearing. That is one of them. So I would like to make the point that although the pack has been received, it is not complete.
Okay, I'll have to refer back to James Chadwick on this particular case.
Yeah, so the hearings regulations which govern the procedure and process for this and the ground rules for this sort of hearing state that relevant representations must be received, can be made within a certain time of the matter going to consultation. So I'm satisfied that all the representations were received within time, including the two that were discovered after the report was prepared. And obviously Mr. Beck's was one of those. They have been distributed to the members, and they've had them for at least a day or two, and of course their concern have to be taken into account when making a determination about this. I'll just say from the outset, this is not a planning matter. It's governed by its own hearings regulate, the Licensing Act 2003 hearings regulations. And they contain, they don't contain any provision to when reports and copies of papers are provided to the members who will be hearing the matter on the subcommittee. And Regulation 31 states that any irregularity resulting from failure to comply with any provision of these regulations before the authority has made its determination shall not itself render the proceedings void. And then Regulation 32 says that any time before an application is determined, an authority can take some steps as it thinks fit to cure the irregularity before making that determination. So there is, if there is any defect in relation to this, it has been corrected. The objections of representations are now within the papers, and they must be taken into account when a final determination is made.
Okay, but just to clarify that, in paragraph 3.1.3 of the paper, which seeks to summarize the objections in one paragraph, it omits my key point as being about vehicular activity at night. Now, this 3.1.3 serves to be a summary for all parties to read, which summarizes in big picture terms what are the themes of objections. My objection, which is based on law, is based on vehicular activity at night and various parts that I've referred to in the licensing objectives referring to statute. You have failed to summarize my objection and even the big picture of my objection in your summary in paragraph 3.1.3 of the paper.
Andrew Beck, sorry, the question was, have all parties received a copy of the agenda for today's hearing? You will get an opportunity to speak. If Ed, I beg your pardon, if James Chadwick is happy to continue, then I'm happy to proceed.
I respect that. I'm just drawing attention to the fact that the paper is incomplete.
Thank you very much. Sarah, I will come back to you very shortly. James, are you happy for this to continue?
Legally, yes, because I'll repeat the point. This is not a planning matter. The planning protocol does not apply, and paragraph 3.13 literally says potential increase antisocial behaviour littering, amongst other things. A copy of the relevant reps is seen at Appendix B, and those two late representations have been added to Appendix B.
Thank you, James. So, Sarah, your hand's up. Can we come to you, please?
Yeah, only very quickly, Chair, just to say that I don't think I've received the last reps that Mr. Chadwick and Mr. Beck are referring to. I've got no problem whatsoever with them going in and Mr. Beck referring to them and you seeing them and all the rest of it. I just don't think they've actually made it to me personally. So if at some stage somebody could forward them on to me, I would be grateful just to take a look at those things.
That's fine. I'll ask Ed from Democratic Services to forward that on. Okay, so please let's continue. This hearing is in respect of an application for full variation of a premises licence. I would like to invite the licensing officer to introduce a report, please.
Thank you, Chair. So on the 16th of January this year, the West Northamptonshire Council's licensing department received an application for a full variation to a premises licence for McDonald's situated in Kettering Road, Northampton. The existing licence for the premises currently authorises the restaurant to provide late night refreshment from 2300 hours until midnight, Monday to Sunday, with opening hours from 6 until midnight, also Monday to Sunday. Obviously, opening hours in themselves aren't a licensable activity. However, the variation is seeking to increase the late night refreshment hours, which obviously, if it operates between 5 in the morning and 11 at night, doesn't require any license, but it's the hours of 11 in the evening up until 5 a.m. that do. So this is basically applying to extend the late night refreshment so that the premises can trade essentially 24/7 in the sense they could go all of those times. So when the application was received, the 28-day consultation period began, which obviously is the opportunity for interested parties to submit relevant representations in relation to the application. And as we've discussed slightly already, during that consultation period, a number of objections were received and relevant representations submitted. By way of a background, a previous full variation application was made by the premises licence holder in November last year, which also sought to vary the licensable activity of the provision of late night refreshment. The application was refused at a hearing held on the 2nd of January this year, and the decision was the subject of an appeal to Northampton's Magistrates Court, with the matter being listed for a direction hearing at Wellingborough Magistrates Court on the 24th of March.
Okay, all right, okay.
The new application includes an updated operating schedule compared to the earlier application received, especially in regards to the steps that the licence holder intends to take to promote the licensing objectives, which was not addressed in the previous application. The issue arising as a result of the representations received are that there are concerns about potential increases to matters such as antisocial behaviour, littering, noise, unpleasant odours, along with other things which we obviously mentioned in people's own addresses. The choices that the subcommittee have is to modify the conditions of the premises licence or to reject the whole or part of this application. The conditions of a licence, including the hours during which any licensable activity takes place, are modified if any of them are altered or omitted or any new conditions are added. Thank you, Chair.
Thank you very much, Michael Sands. So we're now going to hear representations from each of the parties. All parties will have an opportunity to make representations later in the hearing. At the end of each presentation, you'll get an opportunity to ask questions, and please keep your questions only to what you have just heard. So now I'd like to invite the objectors to make the representation. So if, again, to avoid everyone speaking at once, if we can have the objectors raise their hand on the screen, and I will come through the process one at a time, please.
I don't know how to raise my hand on the screen. I'm sorry, this technology's past me.
Okay, Andrew, that's fine. I'll come back to you shortly. Let me just check the others. So in that case, Andrew, it's over to you. No one else has raised their hand from the objectors, so it's over to you.
Cece has got sound problems. I believe she wants to speak as well.
Okay, if she has sound problems. So Andrew, okay, that's fine. So we'll start with yourself, please.
Okay, so so first of all, I'm grateful that you've included belatedly my objection. I urge you to read it. But in terms of my my spiel for today, thank you very much for inviting me. Your report explains that under paragraphs 9.43 to 9.44 of the Licensing Act, your decision must be evidence-based, appropriate and proportionate. The burden rests squarely on the applicant to show that the extended hours would promote, not undermine, the licensing objectives, and they have not done so. There has been no material change since the last refusal. A near identical application was refused on the 2nd of January. Your report, section 3.1.4, contains nothing, confirms that nothing materially has changed in the locality or its impacts. The new paperwork does not alter real-world outcomes. Residents confirm their experience has also not changed. What real-world change has occurred since January 2026 refusal? Can the applicant identify any new evidence that demonstrates reduced impact on residents at night? Paragraph 2.21 requires you to consider the effect on nearby residents, noise, odours, litter, disturbance. Your report at paragraph 3.2.1 identifies the key nuisance as vehicle-generated noise, engines, idling, acceleration, door slabs, queuing, and courier activity. The applicant has not proposed a single measure that reduces these external impacts. What single measure actually reduces vehicle noise between 2 AM and 5 AM? How do you prevent engines, door slams, acceleration, or drive-through queues from disturbing residents? Where is the decibel evidence showing the premises can operate quietly overnight? The courier management plan is undetailed and unenforceable. There are no limits on courier numbers, no dwell time controls, no enforcement steps, and no monitoring. The applicant cannot control couriers on public roads, meaning idling and noise will continue or worsen, exactly as residents describe. Where are the courier limits, the dwell time rules, and enforcement procedures? How can you stop couriers from idling or waiting in surrounding streets? What is the sanction for courier non-compliance, and who enforces it? The internal measures do not address the external noise. CCTV, staff safe, training, and quiet exit reminders do not address external mechanical vehicle noise. Paragraph 2.27 confirms the limits of off-site control, which is why these measures cannot solve the nuisance. How do staff reminders prevent engine noise, acceleration, and door slams? Which of your mitigations operates outside the premises where the nuisance actually occurs? I'll repeat that point. Which of your mitigations operate outside the premises where the nuisance actually occurs? And I'm not just talking about rubbish picking here. I'm talking about engine noise. Public safety concerns persist. Paragraph 2.8. places responsibility on the licence holder to ensure user safety. Late night vehicle movements, courier activity and pedestrian interaction increase risk, and the applicant has provided no new mitigation. Your report acknowledges these concerns. What new safety mitigation has been introduced for increased late night traffic and courier movements? Paragraph 10.14 gives you clear authority. Where extended hours would undermine licensing objectives, you may reject the application. The evidence shows that extended hours will undermine both public nuisance and public safety. Members, the applicant cannot control or mitigate vehicle-generated noise. That is the heart of this case. Nothing material has changed since the previous refusal. Every representation and your own report shows the licensing objectives would be undermined. Under 2.21 and 9.43 to 9.44 of the legislation, the only appropriate proportional decision is refusal. And on a personal matter, I want to say that one further thing. This site is in a residential area. It is not a motorway services station. It is a residential area. It would be the only site in a residential area that would be open 24/7 like a motorway services. Find me a motorway services station that is surrounded by density of residential housing like this one. The fact is he wants to turn this into a motorway services, which is completely inappropriate to the residential area in which we live, in which we raise families, in which we seek to have a peaceful life. And additionally, whilst you say it's not about planning, I draw attention to the fact that this originally went through planning without any engagement with residents in the community. You pushed this through planning last summer, and you got it through some closed shop without engaging with residents. And my colleague, fellow resident John Crick, has drawn attention to that, and you failed to address that issue. There remains major procedural issues with this, not just licensing application, but the entire project. And furthermore, do you not think it's a waste of time for him to continually be putting in these repeat licensing applications month after month when he's only just put one in before? So nothing material has changed. The applicant still cannot mitigate vehicle noise driving this case. Every representation in your own report show the licensing objectives will be undermined. And under 2.21 and 9.43 to 9.44, the only proportionate decision is refusal.
Thank you, Mr. Beck. So am I correct in saying, are you going to read something out from John Crick, or is it going to be echoing your remarks?
John Crick was obviously entitled to attend this. I would like to draw attention to my own representation, which has been belatedly put into the pack, and I asked Michael Sands ahead of this meeting to have additional time to go through that, and I would like the courtesy to be able to do that, please.
That's one for you, James, please, if you can aid in any way.
It's a matter for you. I'm just like to make it clear that the hearings regulations also say that people who've made representatives may only expand upon their representations and not introduce new things. The representation is the written piece, the written representation that has been received. It's not a starting point to expand it. Any submissions made further to that representation must concern information that's in that representation, not expand it onto other things. That is in the hearing regulations.
We're happy to continue with this committee. Thank you, Mr. Beck. So let's move to Cece, please. No, Cece, you're on mute. I appreciate you may be having technical issues, but if there we go, that's better.
Yeah, I got Okay, can you hear me now? Because I've been
Yes.
struck here.
Cece, your connection's not very good. Your connection's not great, so you're very intermittent.
Okay. No, I know. I've checked my Wi-Fi. My Wi-Fi is great. It's just that there's an unstable connection, which doesn't help when the volume of traffic goes past this. So that's the issue we have. The sheer volume of traffic come down this road will just makes it unstable.
Sorry, through you,
My
Chair.
concerns around
Cece,
this,
if you turn your camera off,
application process,
then your sound might be a bit better.
is the quality of actually living.
Yeah. Cece, I'm sorry, we're going to have to. This needs addressing because we can't understand a word you're saying.
Order.
Cece, if you try turn your camera off, your reception may be better.
No. Oh, gosh. I cannot get this to go off.
Cece, in that case, I do apologise, but we can't understand a word you're saying, so I do apologise. Okay, in that case, let's continue. Let's move on. Sorry, Cece. I mean, feel free to come back if you can improve your connection.
Could I suggest that Cece dials in from her phone? If you could make that suggestion to her, please.
Yeah, Cece, can you dial in from your phone at all? Will that improve the connection? What we'll do, Andrew Beck, we will continue with this committee, and if Cece does improve her connection, we'll give her the opportunity to speak.
Thank you.
Okay, happy. Okay, so are there any questions from the licensing officer?
No, thank you, Chair.
Thank you very much. Are there any questions from the applicant?
No, thank you, Chair.
Thank you. Are there any questions from the subcommittee?
No, thank you.
Thank you very much. Okay, so I would like to invite the applicant to make their representations, please. Again, if you could raise your hand on the screen, that'd be much appreciated, and we'll go through them one at a time.
Yeah, I think it's primarily going to be me and then questions for those I represent, if that's acceptable to you.
Most certainly. Please continue, Sarah.
Thank you. Good morning to everybody. So you know that I'm here with Perry Akhtar, who's the owner of Casper Restaurants, the applicant, and Mark Buckley, who's his operations manager. Now, Mr. Akhtar, since the last occasion, has put in a very extensive written statement, which is pretty much everything he would want to say to you. So I'm drawing all of that together today in this application, and he is here to answer any questions with Mr. Buckley, who can also answer any questions that you have, but that's the way we're going to do it. And then we have Mr. Daryl Butterworth, who is an eminent ex-police inspector, now turned licensing consultant, who's done some on-site investigations, like a mystery shopper kind of thing, to look at some of the potential impacts and actual impacts of this site, and he's here to answer some questions as well. So with all that in mind, I will draw this application together for you, and it is true to say that it is off the back of the previous application that was made and then refused on the 2nd of January. I conducted those proceedings as well. The decision letter is not accepted by the applicant, and it's gone to appeal, as you know. And the directions hearing is on the 24th of March, and this really is an opportunity to sort it out. So rather than go through long and expensive and extensive appeal proceedings, which not incidentally will thwart the whole purpose of the grant of the temporary planning permission, because that expires in November. It was granted November to November, and I'll touch on that a little more detail in a moment or two. But by the time any appeal is heard, that planning permission will have run out. And so what we're trying to do, what this second application is trying to do, is to fill in any of the gaps that the previous committee thought might be there up front, what you're seeing, and you'll have received hopefully quite an extensive pack from the applicant this time, comprising a statement from Mr. Actor, comprising on the ground evidence from Mr. Butterworth, who went out to do his reviews, comprising updated policies and management plans, really trying to give that holistic picture to the committee now to preempt what might happen or be done in the appeal. So that's transparently what's going on. So it's right to say in a sense that nothing's changed, but hopefully the committee will feel they have more evidence now to answer any of the concerns that the previous committee felt were still outstanding. Because of course this is a prospective application. You understand how late night refreshment works. It doesn't need a license up till 11 o'clock at night at all. This outlet has got a license from 11 till midnight, and this is asking for the extension between the midnight hour and 5 o'clock in the morning when it doesn't need one again. And that's how it works. And it's important to add the opening hours to that, because although they're not licensable, they have to go on the license, so they also have to be commensurate. So that's what's going on, and that perhaps explains a query as to why again, why now, why like this. I hope that helps with that. And when you're considering this application, together with all the paperwork, and I'm sorry if it seemed quite voluminous, but hopefully everything that you need will be in there, as well as looking at that, would you please also look at the previous decision notice of the previous committee and the without prejudice letter that will be available to your legal department, which is again trying to preempt what this appeal will do. So looking at the substance of the application, then you will see from all the details that have been put in that Mr. Akhtar is a very experienced franchisee. His journey in actual fact exemplifies what employment opportunities McDonald's actually offers. He's the living example of going in from flipping burgers to owning 10 restaurants. And you understand, and his statement explains how the franchise system works with McDonald's. I think people have the idea of McDonald's as being this monolithic monster business. In actual fact, the way it's predominantly broken down is in terms of local business people who are running their own restaurants in a franchise model. So it's their business. It's Mr. Akhtar's business, and he engages with his community and he contributes to his local areas in the ways that he sets out in his statement. And it's in that sense a very local enterprise. He's now been a franchisee for 22 years. Over all of his restaurants, he employs 1,227 people in the Northamptonshire area. He has trialed what he wants to do with this restaurant now in terms of temporary events notices. So we do have some on the ground de facto evidence of what kind of impact it might or might not have. And importantly, this proposal has been studied now by multiple experts, acoustic experts, antisocial behaviour experts, Mr. Butterworth, ex-police expert. Obviously, all of your professional consultees have been consulted now, not once but twice. So for the January application and again now, and that's a very important point that I really want to emphasise in a moment or two. But there has been no feedback of any description, negative or otherwise. There's been no feedback from any of the responsible authorities about the temporary events notices, about the trial of the later hours. And what's important to understand, perhaps, is that the primary driver of this application, because it's not primarily profit. And I think that was one of the things that the previous committee perhaps misunderstood. It's not about profit primarily, it is about business sustainability. But those two things are different concepts and they are different matters. It matters to Mr. Akhtar to be able to service his staff as well as his staff servicing his restaurants. And by that, I mean that if he operates shifts that end at midnight, he's then got staff who are staying in the restaurant to clean up and do all of the things that are required to stock up and all the things that are needed for the next day. And they end up leaving the restaurant in the middle of the night when there's no public transport and it's complicated and difficult for them to get back. That's not a good staff experience. That's not what he wants. It's not what happens at other restaurants. If he has an overnight shift, he can have people working, coming onto their shift at 11, 12, 1 o'clock, whatever it might be, working through the night, finishing in the morning again and going off. Now that's a shift pattern that works for him, works for his business, works for his staff. He can't do it on the hours that he's got. Another very important factor for all of the restaurants, and they feed symbiotically off each other in this respect, is customer experience. So if the customer expects local McDonald's to be open 24 hours and one of them isn't, that's irritating, and that deflates their customer experience, and they have a negative reaction to that, and that impacts on all of the restaurants and the reputation of the restaurants and so forth. So for Mr. Akhtar, it's important to have that smooth overall customer experience, and that's part of his business model and his business viability. So that, in actual fact, the number of additional sales that would be made overnight is not the point. It's not particularly high. He would be looking at, and this is all in his statement, paragraphs 15 to 17 for your reference, he'd be looking at something like 33 customers overnight in this particular period. Between midnight and 5 a.m. and that's taking comparisons from other restaurants that have the 24/7. 29% of overnight orders are online deliveries, so that would be around about 10 deliveries through that period of time. These are pretty small figures, and of course that plays into the impact that they would or wouldn't have on local people. So the idea that this is going to drive massive footfall, massive car visits, long queues through the drive-through is not the reality of the situation. I think Mr. Beck was talking about real world evidence. Well, this is real world evidence, and this is by comparison with what the other restaurants do. And it's not what Mr. Akhtar needs out of this application. He needs something different. The grant would create 20 additional jobs in this particular restaurant. That's something that's important to him as well. Coming back to real world evidence, what is very important for the committee's consideration is the case of Thwaites. And you will have come across this case, no doubt, your legal advisor certainly will, but the case of Thwaites is an absolute bedrock in licensing law, and it says that when the responsible authorities are content, that should have a profound impact on the decision making of the decision maker, whether that be the licensing committee or whether that's the magistrates on appeal. The police now have had 2 opportunities to react to this application if they wanted to raise any concerns that they might have about antisocial behaviour, boy racing, driving in the locality, anything of that sort. They are content. Environmental health are absolutely critical to your consideration here, and in a moment I'll explain their input into the planning exercise, which is highly relevant, but they too have had these 2 opportunities now to give you feedback on whether they believe in their professional capacity that this application will have any negative impact on the licensing objectives. They clearly do not. We've pushed that, we've tested it by writing to them specifically between the last application and this one and saying, do you have any concerns? Are you engaged in any way by local complaints, local issues, local problems about noise, antisocial behaviour, rats, vermin, litter, anything? Do you have any feedback to give us? Have you had any complaints? And the answer was no. We have had no complaints or feedback about this restaurant since its inception in 2019. And that's a seven-year period of no complaints. So when the residents make representations, as they have to the past application and this one, saying it is Armageddon or it's going to be Armageddon, that is against the context of never having said so to anybody else. Environmental health have no record of complaints from residents. We've seen no record of complaints through the licensing authority or the councillors. Nobody has given us feedback about that. And none of the local residents have ever made a complaint directly to Mr. Akhtar and the restaurant. So that is real world evidence. That is the baseline against which these applications have been made. And what we know is that the later hours have been trialled in between the last application and this one. Apparently the residents didn't know about that, and they wouldn't, because they're not notified about TENS, they're not required to be. And obviously the impacts that actually occurred were so negligible that they didn't notice it was happening. And that too is real world evidence. So the the Daniel Thwaites point, the case point, is of legal significance. So you have factual material to consider in this application, but you also have legal issues to consider in this application, and it's the legal issues that will end up going in front of an appeal court should regrettably that become necessary, which is not what anybody wants, but that is the prism, the lens through which the magistrates court will view these matters. It's not a complete free-for-all in a decision-making context. It has to be done against the legal tests, and Thwaites is absolutely up there. No enforcement action has been taken against any Caspar restaurant, in actual fact. So it's not just a question of this restaurant hasn't attracted any complaints or issues or problems or concerns. None of them have. Mr. Caspar has, Mr. Actor has a completely clean record with all of his restaurants, and there's no negative feedback about any of them, which tells you important things about the quality of his business style, his management, his engagement with his community, and the way in which he deals with the responsible authorities, and they are content with him across the board. Other restaurants of his are in much more densely residential areas than this one is. So to suggest to you that this is an outlier, a quasi motorway service station.
Sorry, I'd like to object. I'd like to object to that. That is not the case. That is not the case. The other areas are not as densely populated as this one.
If you please refrain, otherwise.
Okay, I will refrain. I will refrain. Thank you. But I do need to correct that. That is not actually factually correct. If you look at the one at Western Fable,
I am going to step in here.
Correct.
This is not appropriate.
Yeah, I completely agree. Mr. Beck, please do not interrupt.
Chair, can I just point you to the hearing regulations that I can't remember which one it is, but you have the power to prevent anyone from attending the hearing and remove them if they are disruptive.
Okay, thank you very much, James. Thank you very much for that. But I will go back to Mr. Beck. So you will get an opportunity to ask any questions to the from the objector. So you will get an opportunity, but please do not jump in. Sarah, please continue.
Thank you very much indeed. I maintain it's a fact. Other restaurants are in more densely residential areas, and it's an empirical fact. It's capable of proof by way of evidence, and obviously that is what would happen in an appeal. In the context of crime and disorder, antisocial behaviour, Mr. Akhtar has taken the trouble, as you've seen, to send out Mr. Daryl Butterworth. Mr. Butterworth is a highly respected licensing consultant in the field. I've worked with him numerous times. He is an ex-police licensing inspector, so his knowledge and context of licensing law is unparalleled, and he knows exactly, as an ex-police inspector, what he is looking for in terms of actual impact, on the ground impact, and potential impact. And of course, both things are in play here. He went out to do his site visits since the last application, so this is new evidence in front of you. On occasions when there was no 10 application in place, so the ordinary hours were in operation, and also when there were 10s in play, so he could see what was happening through the extra hours, and that would have been indicative perhaps of additional footfall or visits or anything of that sort. But he was also alert to any other potential impacts that might be arising either way, the potential for noise to reach as far as residential dwellings, the potential for traffic noise on the car park, because obviously he was seeing other vehicles moving around on that car park. You appreciate it's not just McDonald's car park, you understand how that works. And his report, therefore, is highly instructive. He was able to observe for any evidence of rats, vermin of any sort, litter, all of those sorts of things, and his reports are quite comprehensive. I won't attempt to go through them with you here now and take up this time, but I do invite you to look at those very, very closely. He was satisfied that there was no evidence showing up of public nuisance, including from delivery drivers. He was able to observe that the car park was mainly used by non-McDonald's customers, and his very clear conclusion was that there would be no adverse impact created by these later trading hours. And he was able to make observations about the distance of the nearest residence and the volume of traffic already on the Kettering Road, which, as Cece Beck has indicated to us, is of such a great volume that it can actually impact on internet stability. The planning permission I will come to. This is hugely important in this case, and this actually starts to trickle into public law issues of irrationality, because when the same council, the local planning authority, which is the same council, granted this temporary planning permission from November to November, now we're sort of getting regrettably far into the lifespan of that temporary planning permission, they looked in excruciating detail at all the potential impacts on local residential amenity. That's a planning test. But for practical purposes, the difference between residential amenity and negative impacts such as odour, noise, antisocial behaviour, vermin, litter, all of those things in the context of a planning test is no different de facto than the tests under the Licensing Act of impact on public nuisance. They're the same things. So although the tests are different and although the licensing regime operates separately from the planning regime, they are not in watertight compartments, and the law makes that very, very clear. And you've also got the new National Licensing Planning Framework, the NLPF, which says expressly in it at paragraph 5.4 that it's important that licensing decisions do not undermine planning decisions. So the idea that one must close one's eyes completely to a planning decision is not true. The context is very important. And when you have the same decision maker saying with a planning hat on, these impacts are not unacceptable, that this later trading will not cause unacceptable impact, it then becomes irrational to look at the precise same potential impacts and say, we can't be sure that they won't cause impact. So, well, you can, because you just did. And that's a very important consideration and will be taken very seriously in an appeal context. Without the license, the planning permission that the council's already granted cannot be tested. It's a test. It was intended to be a test. It was intended to be a trial run until November. If it doesn't work, if it didn't work in the planning context, the planning will end. In the licensing context, the licensing could be reviewed and removed. So the idea that this is an open floodgate that can never be closed again is entirely wrong. And the prospective context of the decision that's already been made, you know, we can't be sure, we must prevent this risk, is excessive in the context of the risk trial that has already been approved. And it's not been approved on a wing and a prayer, it's been approved on a comprehensive set of reports, professional reports. And again, I bring back in the responsible authorities, because the police will have looked at it, environmental health will have looked at it, licensing will have been consulted on it if they wanted to or needed to be. It's the same professional officers looking at the planning permission and saying that's acceptable, as have been consulted on both of these licensing applications, and by their silence have acquiesced also and saying we don't have any objections to bring to this license application. It's the balancing out of that decision-making exercise. So for the January committee in their decision letter, as they did, to treat their decision as completely siloed and separate from the planning outcome was incorrect, and a matter of as a matter of law incorrect as well. So just looking in a little bit more detail at the resident representations, the ones that were made last time and the ones that were made this time, there are some empirical factual inaccuracies which are capable of demonstrable proof. Things like the litter picking, for example. There's a lot of minimising in the residential representations about litter picking. It's not a matter of opinion. It's not a matter of agree to disagree. It's empirical fact, and it's capable of demonstration through logs and records, photographs, staff evidence, witness evidence, testimony. I do this. This is part of my job. I do it every day. I do it in the way that's been described. And the details are set out in Mr. Akhtar's witness statement. So you can see the precise times of the litter patrols, 7 a.m, 2 p.m, 7 p.m, ad hoc checks every 30 minutes. Mr. Beck is still interrupting by making noises. It's not acceptable.
I think he's just put himself on mute, Sarah, so please continue.
Thank you very much. The litter trolley, the personal protective equipment and so on, it's not a matter of opinion. And that is evidence that would be strongly brought to the appeal environment. No resident has ever raised litter complaints directly with the restaurant, or as I say, with any of the responsible authorities. That's not information that's been passed to anybody. And Caspar restaurants are active, proactive participants in the Clean Up Northampton bid campaign and the Love Where You Live community litter events. And that's set out in Mr. Actor's statement at paragraph 73 to 74. Similarly, antisocial behaviour, boy racing, cars, vehicle noises, that kind of thing. It's all been the subject of close attention and monitoring to see what the reality is in the planning context and now in these two licensing application contexts. The original noise impact assessment by Sustainable Acoustics was done for the planning application, and you can read that noise assessment in its entirety, and the details are set out in Mr. Actor's statement at paragraph 22. The projected, this is prospective noise impact. The professional report was done in order to calculate what the likely operation overnight would do in terms of residential impact. It was professionally modelled against comparators, as you would expect, but also the surveys, the on-site surveys were actually done, so real life evidence taken about levels of noise, ambient background, the levels of noise of the road already over which any additional noise from the restaurant would have to come before it could reach residents, and antisocial behaviour. And the feedback from that professional report prior to these licence applications was that no antisocial behaviour was observed during those surveys. Now, it's right to say that all these different surveys, Mr. Butterworth, Sustainable Acoustics, would have been snapshots, but the picture is still consistent. So when Environmental Health are looking at it, when Sustainable Acoustics are looking at it, when Mr. Butterworth is looking at it, the picture is absolutely consistent. There are no anomalies. Well, it was noisy that night, but it wasn't noisy that night. The picture is stable. And it will remain stable. It's contained by the noise management plan. The policies and the management plans that have been put forward by the Caspar restaurants are not speculative and they're not amateurish. They are the controls that are applied successfully to other restaurants, and that's why they don't have any complaints. And they're professionally prepared. So they're done by people who know what they're talking about, what measures work. Mr. Beck said, well, how can you possibly control delivery drivers? How can you possibly control what they do? That's all set out in Mr. Actor's statement. There are measures that can be taken, direct and indirect. He has professional relationships with the delivery providers, the Deliveroos and the Uber Eats and so forth. If he's not satisfied with the behaviour of the delivery drivers, he doesn't use them. So they have a downward pressure on their delivery drivers to behave. Mr. Actor has direct pressure on delivery drivers. If he identifies one in particular that's causing a problem, he will ban them from collecting from his restaurant. He doesn't have to have delivery drivers who are causing problems. So there are specific interventions that can be made. And then there are wider management interventions as well, all set out in the statement and in the noise management plan as well. I won't go through it in detail, but I hope that you will look at it. Comprehensive CCTV, public view monitors, footage available to the police upon request, body-worn cameras on the staff safe system, that was explained in quite some detail previously, and again, all of that information is available. Mr. Actor's statement, paragraphs 51 to 55. Managers trained in conflict resolution, antisocial behaviour management, their 5-step approach and their trickle-down training, so they are trained to a high level, and then staff, colleagues within the premises are also trained in what they would need to do. And this is spread across all of Mr. Actor's restaurants, so it's not speculative for this one. These are the measures that are actually implemented and actually work. Deliveries, I think there's been some mention made about deliveries, that those are curtailed. They're 2 o'clock in the afternoon to 8 o'clock in the evening. There are no overnight deliveries. They're 4 days a week. Vehicles are fitted with solar panels to ensure that they are quiet. They're not going to have engines idling while they're stationary. There's been no smells, odours, vermin, all of the points that I have already made. And that's all, again, set out in Mr. Actor's statement, paragraphs 77 to 79. I'm only going to touch briefly, and I am coming to a conclusion I would be delighted to hear, but there's obviously quite a lot to cover here. And this is the alternative, we hope, to the appeal proceeding. So if I can front load it, then perhaps this can be resolved to everybody's satisfaction. And I do mean the residents as well. Mr. Actor is not indifferent to the concerns of his residents, but you won't be surprised to learn that this is not the first time in his career that he has received these sorts of fears and anxieties and concerns from residents when he opens a new restaurant. Same with my career, as it happens. I deal with these a lot. And what I can say is that the resident concerns that are prospectively presented as it's going to be a problem do not materialise. And Mr. Akhtar can speak directly to that in relation to his other restaurants, because, as I've said, there's been no interventions on those. None have ever been necessary. So that, again, is real world evidence. But the National Licensing Policy Framework and the changes to the Section 182 guidance are matters that your legal advisors will update you on. It's contained within the appeal paperwork because this is something that the court will take into account. And really, the committee on the last occasion was, with all due respect to them, quite dismissive about this new licensing framework, and that was wrong. They indicated that they thought it only had application when you came to revise your next statement of licensing policy, and it didn't have any implications for case-by-case decision-making. That's not true. It does affect case-by-case decision-making. They rejected it because it used the word necessary instead of the word appropriate. Well, things that are not necessary are not appropriate. So that fine distinction between the terminology is not appropriate. Yeah. When making licensing decisions, licensing decision makers, which includes committees, must consider the need to promote growth and deliver economic benefits. Now, that's not National Licensing Policy Framework. That's now the Secretary of State's Section 182 guidance. That's statutory guidance. So that's a must do. And the committee dealt with that on the last occasion by saying, well, we don't understand what the growth is going to be. Well, growth needs to be considered holistically. It's not just a question of how much additional profit this particular restaurant will make. It is about viability and sustainability across a business model. And that's what I explained at the outset of this application. There are wider growth issues, business sustainability issues at play here. And those are matters that are enshrined within the council's own statement of licensing policy. As it happens, local economic viability and growth has never been more important than it is at this point in time. And this application feeds directly into that. And there is a certain element of saying it's not for the committee to second guess a business owner's needs when granting an application. If the business owner says it will uphold and sustain their business, that is something to be taken into consideration, unless there is contrary evidence. And here there is not. The community engagement that Mr. Akhtar has is unparalleled. He has excellent community engagement. All of the matters set out in his statement, paragraphs 97 to 100, the support of the football team, the community initiative to reduce violence, it's all in there. Since last time, Mr. Akhtar has reached out to the bid and has received a response which is exhibited for you. An email from Mark Mullen, the bid operations manager, setting out in great detail the benefit that McDonald's contributes to the bid and to the local area, calling them extremely engaging within the business community and stakeholders, and saying this: without the valued support of McDonald's as partners, many of our recent success stories would not have been possible. And that is a high endorsement indeed. So the final point I would wish to make at this stage then, please, is that you consider all your options. Another thing that the committee did not do on the last occasion was to break out of a binary mindset, grant or refuse. That's not the end of the story. If you were to identify particular areas of concern that could be addressed by way of condition, a variation of the variation, some alternative, that must too be considered, rather than an outright refusal which flies in the face, as I say, of the planning grant. It would be appropriate to look at all the options really carefully today. Nobody wants to go to appeal, and if there is a solution to be had, then in everybody's interest, today would be the day to take it. So that's what I'd like to say at this stage. As I say, if you wanted to hear more from Mr. Akhtar about any of these elements, Mr. Buckley, his operations manager, or Mr. Butterworth, who actually conducted those on-site investigations, they are here ready, willing and available to answer questions, but we're not all going to do a speech as I just have. So thank you very much indeed for the time that you've given me, but hopefully that set everything out quite clearly.
No, thank you, Ms. Clover. Thank you very much. So are there any questions from the licensing officer?
No, thank you, Chair.
Questions from the objectors, Mr. Beck? You're on mute, Mr. Beck, you're on mute.
I would like to make a statement at the end. So I would definitely like to make a statement at the end.
You will have an opportunity to summarise.
Okay. My wife does need to speak, so I believe
Yes.
she needs to be given the opportunity. And I just draw attention to the fact that the last representation made by Sarah lasted for about half an hour. So I would respectfully request that the objectors are given as much opportunity to speak as Sarah has just been given. So I would draw that to your attention, that I think it needs to be equitable for all sides.
That's thank you very much for bringing that to our attention. So what we're going to do now, we're going to go to just bear with me 30 seconds, please, guys. Are there any questions from the subcommittee for Sarah?
Yes, I've got a couple of questions. Thank you, Councillor Beryl.
Please.
Yes, thank you, Ms. Clover, for those your representation. Sorry, can you hear me? I've had technical problems myself this morning. Just checking you can hear me.
Yes, I definitely can.
Okay, great. Just a quick question, it may be for Mr. Akhtar or one of the other representatives here. The solar panels you mentioned on vehicles, are they electric, or is that just the solar panels or something else?
I believe so, but I am going to defer to Mr. Akhtar and Mr. Buckley if they would like to give you a little bit more insight into those, because I confess I don't know precisely how they work.
I'll take those if you like. It's regarding the delivery vehicles, Martin Brower, who deliver to site. Basically, one of the concerns was around the noise made from the lorries while they're idling, in terms of keeping them chilled. They have solar panels built into the roofs of those lorries, which actually run all of the chilled and refrigeration parts, so it's not run off of the lorry engine or anything.
Okay, thank you. And you were encouraging or advocating for us to look at the consider the licensing framework and considering growth and viability. But what you outlined at the beginning was that it's imagine that there'll be 33 additional customers during this extended period where it granted, and 10 deliveries. I mean, I'm just wondering why go to all that effort for, what looks like a quite negligible number. And obviously I'm no expert. How can you possibly sort of estimate that number in it? So a bit of a general question, but I would like some.
Yeah, I'll answer that high level, and then I'll ask Mr. Buckley and Mr. Akhtar to come and answer in a little bit more detail. There are more factors at play across a business model than just the individual visits and the individual profitability of one restaurant. How they calculate it is relative to other restaurants in similar localities and local localities, and not other parts of the country, that have similar hours. So it's a guess, it's an educated guess, of course, but the residents' concerns are predicated upon significant footfall and significant vehicle visits through the night. What we're seeking to do is to reassure that that is not, in actual fact, the case, but there are other economies of scale, there are other employment variables, there are other ways of spreading the business across different restaurants, there are reputational issues, there are customer experience issues that overall embed the success of the business more deeply across all of the restaurants. And that is what the licensee wants. Now, there is a certain element to which, to put it as nicely as I possibly can, it's not the committee's business as to why the licensee wants the license. The committee's sole concern is negative impact on the licensing objectives. However, if the licensee says, this will support my business, this supports growth, and the committee do not have any contrary evidence to that, why would they reject that? Why would they reject an experienced businessman's representation that it will support the growth of his business? But having said that, I will defer to either Mr. Buckley or Mr. Actor if they feel they want to supplement that with slightly more detail.
Well, there's currently only 3 hours of the day when there's nobody in the restaurant, which is from 2 till 5 a.m. So when the restaurant closes at 12, the staff have to clean up and go through the procedures. So they leave about 2 o'clock, and then the staff come in at 5 o'clock to open the restaurant at 6 o'clock. This will make it easier for us operationally, because we can serve a few customers while we're cleaning. But not only that, it will allow us to offer 20 more jobs to young people. And given the unemployment rate in the country at the moment, that will be a huge benefit to the local people.
Okay, thank you.
Any more questions, Councillor Humphreys? You happy?
No, thanks very much.
Thank you very much. So what we're going to do now, we're going to go back to CC Beck and give you the opportunity to speak, and then we're going to continue with the committee. So CC, please.
Okay, well, I was just picking up on that last point he made. He said about, well, it would be providing X amount of new jobs. Well, these are obviously are low-end jobs for, you know, you don't make a career out of working for McDonald's, really. And obviously there's quite a nice incentive being offered by the government now for these low-end jobs, where these government are offering employers £3,000 per low-paid employee for anybody under 25. So that's quite a nice piece in the pocket. But that aside, when this premises was first opened up, I did make a complaint, because the first day that opened, there was problems with the extraction system, and it was a constant humming in our garden. Now, I'm not actually directly next door to the property, so I'm quite a far way up the avenue, and it's like having tinnitus when the wind is in the wrong direction. And I did make that point, and I did notify the council that I thought that would be an issue. And obviously never heard anything back about that. When the original planning was put through, they told us that from their investigations or studies, it would offer one more car coming into the McDonald's car park, or the Morrison's car park, and that would be the impact of this premises going ahead. That's not the case. There's a lot of people who go solely to McDonald's who don't go to Morrison's. And obviously now Morrison's has shut their cafe down because their cafe wasn't making the money, because people are now going to Morrison's. So a lot of that conversation that I've just been heard, it just makes no sense whatsoever. We've not heard how we're going to deal with the rats. Some man said he hasn't seen rats, but you go down there and you hang around the bus stop in spring and summer, and you can probably catch at least 5 rats there. We've got rats all the way up this back alley now, which we never used to have. We've got them actually burrowing into my garden, which have now damaged 2 large shrubs in my garden because they've made runs under the garden. He's not dealing with that problem. Why should I have to put up with that problem from my point of view? Why should I have a cost implication on living my life for somebody else's business? It's like saying, well, I work in an office, but I want the man down the road to buy my pens. It just makes no sense. And we said about, well, these whatever boy racers. Chronicle and Echo ran a story at the weekend about a car crash in the Morrison's car park at the weekend, Morrison's McDonald's car park, where a lady was taken to hospital where she was hit by a 24-year-old boy racer driving a Ford Fiesta or Focus. The traffic lights in the area at the end of the McDonald's, whatever you call it, that area, the McDonald's Morrison's building, whatever, the traffic lights there, they've been down at least 3 times now. But people leaving the premises at night are taking the traffic lights out. Never had that before, you know, and these are all things that are cost implication, not only to us as taxpayers or council taxpayers, but also, you know, it's just money wasted that we're having to do all these repairs. Not, you know, I don't see my council tax bill going down when I'm having to fund all this. You know, I feel like I'm paying twice for everything.
Thank you, Cece. Is that the end of your statement, or?
Well, I don't know. There's a lot more about it. The rats is a problem. You know, we had history tells us all about the damage that rats can do, but we're ignoring that. We've got young children, preschoolers at a school there. Now, if the rats were up at the area where I am, I'm sure as hell as they're in their playground as well. You know, and it is a case of, well, I can do whatever I want as long as it's not on my doorstep. Because I don't notice that he's got this premises or he's opened a McDonald's in Caldecott, has he?
Okay,
so
thank
perhaps,
you.
You know, yeah. Let him make them statements when he's got one on his doorstep.
Okay, thank you, Cece. Again, is that the end, or are you happy for me to continue with committee?
Well, I can't really say much because I've got a bad chest at the moment, so I'm struggling with coughing. But
Okay,
so that's about all I can say. But
thank you very much. So what we're going to do now, we're going to go for the list of questions for the objector, and then we're going to come to James Chadwick, and I dare say Perry will come in at the questions opportunity. So, are there any questions from the licensing officer for Cece?
No, thank you, Chair.
Thank you very much. Are there any questions from the objectors? No, thank you. Are there any questions from the subcommittee for Cece? Thank you very much. James Chadwick, your hand is up, please.
Sorry, Chair, you haven't asked for questions from the applicant.
Oh, sorry, beg your pardon. Any questions from the applicant?
I see Mr. Akhtar's got his hand up. The only thing I wanted to ask the committee to get an understanding of, and obviously we don't need the precise address, is how far away Miss Cece Beck lives from the premises, some indication of where she is relative to the premises without
well, let's
disclosing
put it this way. I can hear it, I can smell it, and I see the rubbish truck when it goes because I've got cameras up in my house, so I know exactly how many times I've seen that nice, pristine rubbish cart that's started going up the street.
I was looking more for a spatial measurement.
Well, I don't know a spatial measurement, but you know what? If I give you a spatial measurement, it opens myself up to all sorts of things happening to my property.
Okay.
Leave that with you, Chair.
Thank you very much, Sarah. Thank you. So, Perry, your hand is up, please. I'm not sure why.
I just wanted to answer some of the questions raised in the statement, really.
Yes, please.
Firstly, to say that these are low-end jobs and not career jobs. I'd just like to remind the committee that I started a part-time job at McDonald's when I was college studying. Mr. Buckley also started work for McDonald's when he was studying. All of our business managers who manage each branch have come through from starting as a crew member working part-time. So there are huge opportunities for people. We do not get any money from the government for employing young people. So all of that is not quite true. I do have a McDonald's.
It is true. The government have just announced that today.
Sorry?
I said it is true about the 3,000.
Please, Cece, no
the government
calling out,
have just
please.
announced it today. It's all over the press if you look for it.
Thank you, Cece, for muting yourself. Perry, continue.
And I do have a McDonald's 2 minutes drive from my house in Caldecott.
Thank you, Perry. Thank you very much. Okay, so now we're going to move on to the opportunity to sum up. Now, I would like to remind everyone that it is a summary. We don't want to go through all of your thoughts and opinions again, so you will have the opportunity to summarize. So all parties will now have the opportunity to sum up. You do not need to repeat yourself or make representation in full. So licensing officer, please sum up.
Nothing further to add. Thank you, Chair.
Thank you very much. And have you had sufficient opportunity to say everything that you wish to the subcommittee? Sorry, I beg your pardon. Summary. So just bear with me 30 seconds. Thank you. Apologies about that. I was just confirming something with Democratic Services. So every single person will have the opportunity to sum up. So we're going to start with, if my memory recalls, Mr. Beck was the first speaker. So Mr. Beck, please summarise. Again, you do not need to repeat everything in full. It is a summary.
Okay, well, thank you for that. And I certainly will not take as long as Sarah did in her speech earlier. There's been no material change since the previous refusal. The licensing subcommittee refused the previous application because the premises are located in a predominantly residential area. Late night vehicle and customer activity would cause unacceptable public nuisance. These concerns fall squarely within Section 4(2)(c) of the Licensing Act 2003 and are addressed in paragraphs 2.15 to 2.21 of the statutory guidance, which emphasises the need to protect residents from noise generated from licensed premises, particularly late at night. Since the refusal, the site location has not changed. The residential character of the area has not changed. The predicted harms remain the same. There is therefore no material alteration of circumstances that would justify revisiting the subcommittee's original conclusion. The new application was submitted only weeks after the previous refusal. This raises concerns that the applicant is simply attempting to rerun the same proposal without addressing the committee's reasoning. The statutory guidance requires applicants to demonstrate how they will promote the licensing objectives, particularly when a previous application has been refused. This resubmission does not meet that threshold. The revised operating schedule does not address the actual sources of nuisance. The applicant has added documentation concerning CCTV, staff training, litter patrol, and general household measures. While these measures may support other licensing objectives, they do not mitigate the principal sources of late night noise disturbance, which includes vehicles arriving and departing, engine noise and idling, door slamming, queuing vehicles, delivery drivers congregating or waiting, drive-through operational noise. These disturbances arise from vehicular activity, which cannot be eliminated by CCTV or staff training. The statutory guidance explicitly notes that public nuisance can derive from car parks, queues, and vehicles associated with the premises, and that conditions must be effective in addressing these impacts. In paragraph 220, that statement is made. The courier management plan is vague and ineffective. The application refers to a courier management plan, but refers to no meaningful detail of its content or how it would operate in practice. Even a detailed plan would struggle to mitigate the noise created by engines starting, idling, and accelerating, drivers arriving at all hours, the cumulative effect of multiple delivery vehicles, noise between midnight and 5 a.m. is particularly intrusive in residential streets, and the statutory guidance requires decision makers to consider this heightened security. Paragraph 2.21. The previous subcommittee decision remains valid. The subcommittee has already determined that 24-hour trading at this site is not compatible with preventing public nuisance. Nothing in the new application materially changes the facts assessed during that hearing. The principles of consistency and good decision-making strongly support upholding the previous determination. This application should be determined by a licensing subcommittee. Given the recent refusal and the lack of a lack of significant new evidence, it is important that this application is not decided under delegated officer powers, A licensing subcommittee hearing ensures transparency, public scrutiny, and the opportunity for residents to make representations directly. I've requested that this matter be referred to a full subcommittee in the public interest. Based on the unchanged circumstances, inadequate mitigation, and established risk of late-night public nuisance, I respectfully request that the licensing team refuse the application for 24-hour operation at McDonald's Kettering Road. This conclusion is fully consistent with the Licensing Act 2003, the statutory guidance, and the reasoning of the previous licensing subcommittee.
Thank you, Mr. Beck. Would Cece like to summarise, or is it going to be pretty much echoing Mr. Beck's comments? You're on silent, Cece. Cece, you're on silent.
Nothing's changed. The vermin problem's getting worse. You know, it's just looking rough round there. It's just a blot on the landscape. It's an eyesore. I know that's not a good enough reason to get rid of it, but you know, I don't think our lives should be impacted any more than they have been by this.
Thank you, Cece, for summarising. So, have the objectors had sufficient opportunity to say everything they wish to the subcommittee?
No, I would like to further add that a couple of points. First of all, I have studied the density of property in around Western Fable, where the other site is, and I know that there is less of a density of property in the immediate vicinity of that McDonald's. So I would just draw attention to the fact that there was an inaccuracy made earlier. That particular site at Western Fable is surrounded by a shopping centre and car parks and amenities, which are largely shopping, and does not have the same density of housing that this one has. And the second point I'd like to make, just reiterating the point about a motorway services station. Now, a motorway services station, obviously by definition, is open 24 hours. It has traffic passing by all the time. It attracts traffic because of what it does and because of where it is. I fail to understand why we need to have a motorway services station equivalent in a densely populated residential area that is substantially more populated than Western Fable.
Yes, thank you, Mr. Beck. You've had the opportunity to summarise already. The question was, have you had sufficient opportunity to say everything you wish to the subcommittee, the opportunity?
Well, obviously, we also draw attention to the fact that my original written representation was omitted from the paper, and in the summary in section 3.1.3 did not include the vehicular noise issue, and the committee ought to have obviously read the paper before today, and by putting my representation in at the 11th hour, it has not given me or the proper process, or actually the process itself has been curtailed by the fact that you have not adequately included my representation, and also Mr. Crick's representation. I understand has been. I understand actually it's still not even in there. I would like to ask the committee, have you actually now included Mr. Crick's representation? Mr. Crick is travelling at the moment, but he lives at number 1. He is closer to the site. So my question to the committee is Mr. Crick's representation now in the pack? And have all participants on this call actually read Mr. Crick's representation? Because I will say that I've not read it because I've not seen it.
I've just confirmed it is not on the online, but we have received them and read.
Well, could I just ask whether all participants on this call have actually read Mr. Crick's objections? Because, as I say, I have not seen or read them myself, and I think the proper process ought to be that all representations that have been legally and validly served during the period leading up to this hearing should have been properly read, properly digested by every party on this call, and it's very clear that that has not taken place. It's certainly not taken place with myself. I've not seen it. My wife's not seen it either. Therefore, I respectfully assume that no one else has seen it. You might have included it in the 11th hour, but I would like to ask directly to every participant on this call. It's a simply binary question, yes or no. Have people read Mr. Crick's objection? Because I haven't.
Can I interject here, please,
yes,
and point out?
I was just about to. Yes, please, James.
Yeah.
I need your.
I'll repeat once again. The process and procedure of these hearings is covered by the Licensing Act 2003 Hearings Regulations of 2005. That is the process, and the council may adapt its the process around that as it likes. The hearing regulations are silent on the issue of reports. Regarding representations, the only person entitled to receive a copy of all representations that has been made is the applicant. So there is nothing in the hearing regulations that would be considered a irregularity.
But the applicant's on this call, isn't he? So has the applicant read Mr. Crick's objections?
Mr. Chadwick, I take no issue as to the legal procedure of this hearing. Thank you.
Thank you. Mr. Beck, you're looking for procedural defects that don't exist. I'm quite sure Mr. Akhtar has read the representation because he has been sent a copy of it.
Well, Mr. Crick's you've not included the well, why don't we ask Mr. Akhtar himself? Have you read Mr. Crick's objection, and what does it contain? Because I've not read it. I would like to. You asked me earlier, have I been given the opportunity to speak and cover everything? Well, I've not been given the opportunity to talk about Mr. Crick, who sadly is travelling at the moment, and I have been asked by Mr. Crick to represent his interests, and so I would like to know, please, on this call, I would like to know what Mr. Crick has said in his objections. Could someone tell me, please?
Did Mr. Crick not share a copy of it with you? So he wants you to make representations about a representation he's never sent you.
I've not seen anything. Mr. Crick, I know, has made some representations. He sent me an email on Sunday identifying that his representations have not been included. Now, I've not seen his representations. I would like to know what those representations are. I think we should discuss them on this call.
Well, I think you should ask Mr. Crick that.
Well, Mr. Crick's unable to attend because he wasn't invited.
What about last night?
What about last night? Sorry, Mr. Crick was not in.
Did he not send you a copy of the representation to enable you to address
Mr. Crick has not sent me
on his behalf?
Mr. Crick has not sent me a copy of his representation, but he has sent a copy to the council and to this committee of his representation. But
it will be before the members when they make a determination, and that is all the hearing regulations require. I would encourage you to look online at the legislation.gov.uk at the Licensing Act 2003 Hearings Regulations of 2005. Which detail the statutory process and procedure that councils must follow. And the procedure and process in respect of this application has been carried out in full, including correcting an irregularity, which was the omission of 2 representations from the.
Do you not believe that those 2 representations have been diminished by including them late at the 11th hour? Do you not? Well, if they've not been summarised in paragraph 3.1.3,
none of the representations are summarised in paragraph 3.3.
No, paragraph 3.1.3 seeks to summarise the nature of the objections, and they've not summarised either my representation, which was belatedly included, and Mr. Crick's representation, which I don't even know what it was. And so I'm asking the committee, since apparently you have a copy of Mr. Crick's representation, perhaps we could, as a from a proxy position, we could actually summarise what his representation was. I think it would be this is supposed to be a public hearing in the public interest, and I think we should actually give him the respect and courtesy of summarising what he wrote. He wasn't invited. I don't know why to this hearing. I also understand now he's travelling. So, but I find it very strange that we have this representation, but no one really knows what's in it, and we're not prepared to talk about it. I find it very, very odd.
We do
Mr.
have a
Crick
copy
knows what's
of-
in it, doesn't he?
Yes,
well,
we do have Andrew
Well,
Beck.
could we
sorry,
talk
Andrew
about
Beck.
could we talk about it then, please?
Why?
Could we talk about the content? Well, I think he's made
Why?
I think he's making some valid points, or perhaps.
And
I
they
don't
will
know
be
why.
taken into account when the determination is made.
Could I
Chair,
ask?
you've heard
could I ask the committee to summarise what
about
Mr.
this.
Crick's objections are?
We will take Mr. Crick's application, not beg your pardon, application, a representation into consideration during the retirement.
Could I ask
stage.
what they are? Could they ask?
Have
Could
it
I
right
ask what the
here in front
objections
of
are?
me.
Could I
Unless
ask you
James
what they
tells
are?
me, I'm not prepared to go through what's submitted.
Councillor, I'd remind again, you've got a power to remove someone disruptive from the application hearing.
Thank you very much, James. Thank you very much. Okay, so we will take that into consideration during the retirement phase, Mr. Beck. Okay, so we're going to continue on now with the committee. Would the applicant please sum up? Sarah, please, if you'd like to summarise.
Yeah, very briefly, because it was quite a voluminous application, and I said everything that I wanted to say.
Yes,
so this
please.
really is just wrapping up for you. There are some legal points and some factual points, as you understood when I explained it previously. The Thwaites point I rest on very heavily. It's very important that the responsible authorities are content with this application, and essentially they've been asked twice now, and they are content, and we've double checked, and they remain content. Your remit, as you well know, is the likely impact of this variation application on the licensing objectives, on the 4 licensing objectives. I think Mr. Beck referred to the licensing objective of public nuisance, which is one of the key ones that would be engaged. Paragraphs 220 to 226 of the Section 182 guidance, he incorrectly indicated that expressly refers to cars and car parks. It doesn't. So your legal advisor will know this very well and will advise you, no doubt. But what is also important on the Thwaites point and the responsible authorities point is that if this matter does come to court and the council maintains a refusal, an outright refusal, then the evidence it will be relying on in court will be the residents. So the residents will be the witnesses, and the witnesses will be standing in the witness box in front of the judge and will be cross-examined. And that is the way in which the council will need to rely upon its or to insist upon its refusal reasons, because the residents are the only substantiators of that. So I leave that with you. This is not really rerunning the application so much as pre-running the appeal. And that's why we front-loaded it with all of this information, the expert evidence that would be used, the details that would be used, so that you can see what that would look like and take a view on it. Now the application is strong in terms of the likelihood of any impacts through those additional hours, in terms of the additional trading that would occur. The previous refusal was not justified, and you can obviously look at that in quite some detail at your leisure to see why I say that. You can relate it to the without prejudice correspondence that's been sent in specifically about that. There will be minimal activity if you don't accept that that supports growth. Well, that's part of the matrix. I don't need to demonstrate that it will support growth in order for the application to be upheld and granted. I do need to demonstrate that it is not likely to have any negative impact on the licensing objectives. So you can put growth entirely to one side if you choose to do so. I invite you not to, obviously, but it's not a necessary part of the application. The whole matter will be looked at again, whether anyone wants it to or not, in November, because that is the time at which the other part of the equation, the other authorization, the planning permission, will come up for determination. It's a temporary permission, and the premises can only trade with both parts of the authorizations, the legal authorizations in place. If the planning permission is not renewed, if it is not either renewed as a temporary or made permanent, that's the end of it. License or no license, they can't trade. If the situation is regarded as being satisfactory from a planning point of view, there's still an opportunity to look at it again if actual impacts are demonstrated. If residents come back and say, look, we told you so, and this has happened, this has happened, this has happened, with dates and times and places and occurrences, and it's all relevant. Anybody can bring a review, including the residents themselves, any of the licensing officers, environmental health officers, police, anybody can bring that review back to the committee for double checking at that time if in fact these speculative concerns at this stage manifest themselves into actual real world on the ground problems that can be connected to the premises, because obviously that's something that's been missing from the objections today. So I invite you to look at your decision through that prism of safety net that could be brought back into the equation in November. And I invite you to grant this application as it's presented to you, or at the very least in some format, because an outright refusal again takes everybody to a place that they do not want to be. And it is, in my respectful submission, entirely unnecessary and inappropriate for that to occur. So I commend the application to you. I very much hope that it commends itself to you as well. Thank you.
Thank you, Sarah. So have you had the sufficient opportunity to say everything that you wish to the subcommittee today?
Yes, I'm just going to ask any of my team if they feel that there's a point that they'd wish to make, either to pop up now or to put it into my WhatsApp so that I can ensure that they feel everything's been covered as well.
I'd just like to mention that we operate 8 24-hour restaurants in my group of restaurants, which we have done so successfully for over 20 years. Some of these are close to or in residential areas in Wellingborough, London Road, Wellingborough, Enstone Court, Western Favell, and we've operated these restaurants without any concerns or any complaints. And currently we operate 4 restaurants in Northampton, which again, we have operated for a very long time without any issues or any objections from any parties. Thank you.
Thank you very much. Thank you. So yes, so the subcommittee will now retire to make our decision. The decision of the subcommittee will be communicated to all parties in writing within 5 working days of this hearing. Details of how to make an appeal against the decision of the subcommittee will also be included. And I'd just like to thank all parties today. It is extremely difficult via Teams and Zoom. I'm sure you all can appreciate. It's much better in person, these committees. So I do thank you all for your patience once more.